tonight Catherine Marchi-Uhel, who's our Katherine B Fite Lecture tonight. Catherine is appointed to head the International Impartial and Independent Mechanism for Syria, based on her 27 years of experience in public service and the judiciary. She began her career as a French judge, and she then served as a judge with the United Nations Interim Administration Mission in Kosovo, as well as at the extraordinary chambers in the courts of Cambodia. She has held legal positions with the Peacekeeping Mission in the UN and in the French Ministry of Foreign Affairs. She was also commissioned to serve as senior legal officer and head of chambers at the International Criminal Tribunal for the former Yugoslavia. So this was a very brief introduction. There are many other accomplishments, but I would prefer to leave time for Catherine. So without further ado, Catherine Marchi-Uhel, please.
Thank you, Liz. It's really a great pleasure for me to join you at the 12th IHL dialogs in Chautauqua. I thought when I received the invitation that the theme of this year dialogue was actually quite spot on and extremely interesting. Is the justice we seek, the justice they want. But I must say that I didn't expect a dialogue and a conversation of the quality we had today. It was really impressive, and I want to thank every participant in the panel. I learned myself a lot. I'm very honored for the opportunity to deliver this year's Catherine Fite Lecture. The experience of this pioneer of international criminal justice, the first woman, as Milena recalled us, to join Justice Jackson's staff at Nuremberg, is a source of undeniable inspiration for me. Her steps, along with the steps of other remarkable women who have helped building the foundation of international criminal justice, have guided me ever since I joined, was exposed to my first war crime case in Kosovo after I joined the ACTY, obviously, and then later when I became a judge at the Khmer Rouge Tribunal. But I really continue to be inspired by their example today as I reflect on the adventure I embarked on a year ago when being appointed to lead this novel and innovative mechanism to assist in bringing accountability for the most serious crimes committed in Syria since March 2011. Tonight, I'd like to walk you through some of the key features of this new body, but also to focus in particular on my vision for the mechanism's priority today. This morning, Stephen Rapp reminded us of some of the background against which the General Assembly established the IIIM in 2011, and I'd like to insist a little bit on that. I think that really is important. The estimates of between 30,000 up to 500,000 people killed, widespread allegations of violation of core IHL principles, torture and mistreatment of detainees, attacks on school and medical facilities and personnel, use of chemical weapons, sexual violence crimes, and enslavement, gender-based persecution, large-scale destruction of cultural property, to only name a few. And in spite of these allegations of extremely serious crimes, well, you're familiar with the political deadlocks, including within the Security Council, which ruled out many of the most obvious solutions for accountability, such as referring the situation of Syria to the ICC or establishing an ad hoc tribunal or regional or mixed tribunal. So this is the context in which the GA stepped in, and as you know, the mechanism is not a court or a tribunal, it's not a prosecutor office even, it's been characterized as a quasi-prosecutorial office. It will therefore not issue judgment, not even indictments, but instead it is mandated to collect, to consolidate, collate, preserve, and analyze evidence of these violations, which have been collected by a variety of actors during the last 7.5 years. UN bodies, Syrian and international NGOs, individuals, state, and many others. It is also mandated to prepare files to facilitate and expedite fair and independent criminal proceedings in accordance with international law standards in front of national, regional, or international court, whichever may have in the future jurisdiction for these crimes. In other words, it's mandated to do the essential preparatory work grounded in criminal law methodologies that will be needed for accountability purposes, regardless, in a way, of which jurisdiction will exist at the moment it will emerge to prosecute these cases. This mandate builds on one of the many lessons learned over the last 25 years from the ad hocs and also from the ICC, and the great potential of international accountability mechanism to function as a springboard to facilitate accountability processes, including before national courts. Our mandate offers a model that from the outset sees accountability as extending across multiple jurisdictions and requiring coordination between national and international mechanisms and actors. So, of course, as you know, at the moment our main interlocutors are national courts in Europe and elsewhere, but essentially in Europe. However, we hope that in the future there will be international judicial avenues, and I dare to say I also hope that in the future Syrian courts themselves will meet the standards and be willing to take their part in the accountability process. So, of course, there are challenges for this mechanism. You won't be surprised. No current access to the territory of Syria, a fragmentation and duplication of documentation, and unprecedented volumes of potential evidence of crimes in Syria gathered by a multitude of entities and using not necessarily criminal law standards. And our priorities, and my priorities for the mechanism to date are actually attempting to address those challenges. So what are these priorities? We have undertaken several months ago a structural investigation, and this is really guiding our strategy to collect evidence, but also to build cases. In a nutshell, what the structural investigation is about is to map crime patterns, to examine the contextual elements required to establish core international crimes, so the chapeau requirement of those crimes, but also to take into consideration the cultural, historical, and gender dimension of crimes, focus on the structures of power, the police, the military, the civilian structures, establishing links between individual perpetrators and other higher level ranking individuals, those who wield power and authority over the events. As I said, this is an investigation that is actually, in fact, guiding both the collection and both the collection and the building of cases. What do we mean by this collection effort? We really see the mechanism as having the potential to become a central repository of material and evidence concerning the crimes committed in Syria. And we have now a secure state-of-the-art evidence management in place, which allows us to securely receive this material, preserve it, tag it, and of course retrieve it for use in either building cases, the primary purpose of this mechanism, but also in supporting ongoing investigation before national courts at the moment. And our approach to collection is therefore broader than the scope of the cases we envisage, in order to take into account both these national investigative efforts, but also to take into account already broader transitional justice dimensions, including the face of the missing and the situation of the missing. The data we acquired to date consist of almost 900,000 records, and our efforts toward acquiring existing material held by others is really just at the beginning. The entities from which we collect information, and also, let's be honest, lead information, not everything we collect amounts or will amount to evidence in a courtroom, but a lot of lead information, which is extremely useful. These entities start from, as mandated, the Commission of Inquiry for Syria. We signed a memorandum of understanding with the Commission in March, and we have now acquired a large part, most part of their own collection. We also turn to other UN entities. I can name, for instance, UNOSAT, but also we're engaging with WHO in its monitoring program of attacks against medical facilities and personnel. We are liaising with other international organizations. I will name, for instance, the OPCW, obviously. A recent decision last June at the extraordinary session of the OPCW actually provided in a decision language on cooperation with the IIIM, which is an extremely important step for us to seek to access material gathered by the fact-finding mission. And in part, we hope that will give us an opportunity of reopening the question of access to material gathered by the GIM, the defined GIM. And as you probably have heard, the OPCW is now, by the same decision, given a mandate to work as an attribution mechanism. So it's really, when it comes to chemical weapons, I would say a three-layer system where you have the crime-based material, FFM material, and all the FFM mandate, then the material gathered to basically establish attribution to an entity, which is what the GIM was doing and what the FFM will be doing for the future, and as well a more targeted linkage from the entity to individuals who bear responsibility for established instances of use of chemicals. But we also engage and collect material from the civil society, and I think particularly of the Syrian civil society, who has been relentlessly documenting crimes in Syria. We've engaged with them on various ways, including in distributing surveys to these entities to understand better the type of material they had, but we've also engaged on what I would refer to as a two-way communication. In effect, Syrian NGOs have clearly expressed their dissatisfaction with the way international mechanism, including fact-finding, human rights fact-finding, have been interacting with them. They are, I think, tired of being only considered as a source of, as collectors, a source of information, and they want to take a part in the accountability process, being treated in a way which is probably more mature and more responsible. At the same time, this is a delicate balance to strike between engaging with them, sharing enough information with them so that they feel considered as valid partners, but at the same time remaining independent and impartial. So, as you can imagine, not the easiest, but an extremely important aspect of the work and clearly a priority for us. We've engaged with states, of course, and obtaining materials from states when it comes to intelligence, I would say, can be done via the classic reference to negotiation of memorandum of understanding. When it comes to obtaining evidence that they may have collected and may form part of court procedures, clearly we had to engage into more complex exercises. Some states have already started more than a year ago to basically change their legislation to permit exchange of evidence with the mechanism, and others are in the process of doing it, and other states are considering that an MOU would be enough. We even have one state that actually decided to share evidence with us without needing any particular framework, but that's the exception. The material we collect, I said, is tagged, organized, retrievable, and that's, as you can imagine, a very resource and time-intensive exercise, but a critical one for this mechanism to play its role and to be really a place where prosecutors can turn to either by making requests for assistance, and we have already received a number of them, and we are responding to these, but also when sharing enough information about the ongoing investigation, it gives us an opportunity to act proactively and offer, as we have done already, evidence to those prosecutors. We are engaging in that way with via several means, bilateral contacts, of course, with the War Crimes Unit, but also using the Genocide Network piloted by Eurojust as an interesting point of contact and a great network. Our limitation in terms of engaging with national prosecutors or courts is clearly set in the terms of reference of the mechanism. We can't engage with jurisdictions that do not respect human rights, and we cannot do it either, at least to share information or cases, if the death penalty may apply. These are our limitations. I'd like to say a word of the building of cases, and as I said earlier, we really see the structural investigation as the foundation for this case building, but you won't be surprised if I'm saying that not every crime committed in Syria will be likely to be prosecuted, so obviously exercising discretion independently and impartially is key to make this case building. The selection we undertake is actually guided by both the benefit of the structural investigation, but also by factors including the gravity of the crimes, the level and type of alleged perpetrators, crime categories, which we find to be emblematic of the events in Syria, but also trying to achieve a fair representation of crimes by all sides. That's an important factor. And trying to achieve a fair representation of the harms experienced by men, women, girls, and boys. We're also looking at crime categories and culpable acts or omission that, in our views, have sustained the ongoing commission of crimes. And we also obviously look to complementarity with files developed by the other prosecutorial actors. And also by the civil society, because as you know, some of them are actively involved in building cases and offering them, bringing them to prosecutors. But let me go back to Catherine Fite for a moment and to the relevance of her legacy in the context of our work. Our commitment to international justice at a time where it was rare for women to have a role to play in this field is an inspiring contribution to breaking gender barriers. Significant gender barriers still exist and have long existed and shaped a historical tendency to overlook or mischaracterize gender-based crimes, including sexual violence, and in a way to marginalize victims. So we are really extremely conscious of that, and the lesson learned during those 25 years of more modern forms of justice are really giving us the way forward. We are making the best to situate sexual violence in the broader gender framework, and also in situating sexual violence and other gender aspects of the crimes which arise in the Syrian context as part of the core work, not as something on the margin that the TORs requires us to look at, but really as part of the core work on accountability for core crimes. And when you do that, when you look at those issues with that lens, in fact, you realize that it helps you fulfilling other aspects of your mandate, and in a way adopting a better strategy and identifying lines of inquiry that you may have missed otherwise. I'm not saying it's easy, but I'm saying that I'm really committed to that goal. We also have a mandated focus on crimes against children, and again, achieving both goals is actually requiring us to embed, and we have started doing that from the outset, experts in the various categories of work that work for the tribunal, skills brought to the tribunal. I'm thinking of investigators, I'm thinking of the analysts, I'm thinking of the prosecutors or lawyers. We've made sure that we could recruit as much of those colleagues having that capacity and that skills from their previous practice. And in fact, that's probably the best way of making sure that we don't have just a focal point to remind us of thinking about gender crimes, but also colleagues who are participating to the entirety of the work and have that focus in mind. Before concluding, I would like to focus on two particular issues. First of all, it will bring me back to the theme of this dialogue, the demands of victims and the meaning of justice. We've said in our first report, and we tried to go a few steps further in the second report that we have issued and will become public in September. I'm referring to the report to the GA, that we want to adopt a victim-centered approach, and we are really, that's why I was so pleased to hear the conversation today. We are really trying to articulate what that means in the context of a mechanism that doesn't have a court dimension. So we won't be focusing on those measures that traditionally are taking place in the courtroom. We will have to rely on external support from states for protective measures. We're really trying to look at what does it mean a victim-centered approach when we try to understand what are the various harms experienced by the victims, and not just victims as one category, but the manifold forms of victims in the context of the Syrian conflict. And doing that is not easy when you don't have access to the country. Doing that is not easy when you don't have cooperation from the country where the crimes occurred, and where some communities may find it difficult to actually trust a mechanism created by the General Assembly that their authorities doesn't recognize as being legitimate. It requires you to really go out of the box and think out of the box and try to really give meaning to that goal, but I think that's an extremely important one. The second aspect I wanted to emphasize again, I touched upon it earlier, was a particular role that civil society, and Syrian civil society in particular, has played in documenting the conflict. In our position, we probably started implementing this mandate with the idea that, of course, Syrian civil society, in spite of their skepticism, wanted this mechanism and would obviously turn their materials to us with the trust that is required. In fact, we realize that it's much more complex than that. Well, first of all, it's important to explain how this central repository system that I explained earlier can play a role and give value to the material that they've gathered. A number of them don't have access to the prosecutors, don't have access to the courts. Some of them do, and they've been actually active in building cases, so they probably don't see how the mechanism can bring anything to them. They only see us as having the potential to build cases for higher level perpetrators for the future. When we are telling them that we're interested in actually supporting national prosecutors at the moment, they're not necessarily entirely pleased to hear that and don't see how that couldn't be a competitive exercise with the work that they do. So it's really building the bridge in this respect, explaining how we can collaboratively, while retaining our independence and impartiality, work toward the same objective of bringing justice to the victims. At the same time, it's also explaining to those who do not have access to the courts that the material they gathered can, when seen together or in cooperation, in combination with other materials, actually make a difference in one particular case, in a case that we build or in a case that prosecutors are currently building. So a lot of explanation. We have adopted a platform which makes us meet with Syrian society representative twice a year in Lausanne. We're meeting with a number of, at the moment I believe, 28 Syrian civil society actors. That is a drop in the ocean of those Syrian civil society actors. And we are identifying and implementing other ways, other means to enter into contact with the broader community. We're doing that by actually speaking to groups elsewhere than in Lausanne, but also I was recently having bilateral dialogue with some of the NGOs or group dialogues in using the gathering that the UN organizes in the region, and it's going to be a necessity for us to emphasize that and to again continue to build the relationship. That's really key if we want both the various communities of victims to understand what we are doing, and also to make the best use of this extremely important work that has been done during the last 7 years. I'm very mindful at the same time, while I'm saying that, of the disillusionment of people most affected by the crime. I think they don't necessarily see the prospect of justice as tangible, and it's really our responsibility to build the trust, not to give them false hopes, but make every opportunity to use the expression Stephen was using this morning, fill the glass, and getting us closer, step by step, to accountability for these crimes. So I really thank you for your attention, and it was a great pleasure to join you again. Thank you.